discuss the statutory recognition of Audi Alteram Partem in India. In India, the doctrine has been statutorily conceded in all important statutes setting up the administrative tribunals. In this respect, the portion in Great Britain is quite similar to that of India. Nearly all the important statutes providing for tribunals in Great Britain contain sections which maintain this rule of natural justice. In India, under the Income Tax Act 1961, the right to hearing has been very widely made available. An order prejudicial to the SSC cannot be passed by Assistant Commissioner Appeal or the Appellate Tribunal without giving him reasonable opportunity to meet this the case. Section 254, Clause 1 of the said Act again provides the Appellate Tribunal, after giving both the parties to the appeal an opportunity of being heard, pass such orders thereon as it thinks fit. As it thinks fit, proviso of Section 254, Clause 2 lays down, provided that an amendment which has the effect of enhancing an assessment or reducing a refund or otherwise increasing the liability of the SSC shall not be made under this subsection unless the appellate tribunal has given notice to the SSC a reasonable opportunity of being heard. Thus, the provisions requiring the income tax authorities and the appellate tribunal to give reasonable opportunity to show cause or to represent one's view are made whenever the interest of the SSC are affected. Under the Representation of the People Act 1951, Representation of People Act enacted enforced in 1951, provisions for hearing are like that under Civil Procedure Code when an actual suit is tried by the court. The rules regarding the appearance of the opposite party, the production of evidence are same as they are laid down in Civil Procedure Code. Under the Section 85 of the Act, the proviso clearly guarantees the opportunity to be heard. Section 85 lays down if the provision of Section 81 or Section 82 or Section 107 has not been complied with, the Election Commission shall dismiss the petition. Election Commission shall dismiss the petition when the provision of Section 81 or Section 82 or Section 107 shall not be complied with, that means not followed. Provided that the petition shall not be dismissed without giving the petitioner an opportunity to be heard. That means Audi Alteram Partem means there must be opportunity. Opportunity must be given in order to present the case to the accused. Under Section 35, Clause 2, Clause 3 of the Copyright Act, the Copyright Board is required to give notice and a reasonable opportunity of being heard. Subsection 2 of Section 35 Clause 2 provides the Copyright Board shall in respect of every such rule give notice thereof. Subsection 3 of Section 35 again provides the Copyright Board shall, after giving such society and the person who lost the objection a reasonable opportunity of being heard, and after making such further inquiry as may be prescribed. Welcome everyone. Thanks for watching this live. Thus, if we look into the principal statutes of India which provide for tribunals, each of them contain provisions for an opportunity of being heard, where the right has been conceded in express words. It shall be assumed as an essential requirement of the fair procedure. But where rights of persons are determined in judicial or quasi-judicial manner, it is essentially furnished. In United States of America, under the Administrative Procedure Act, the right of being heard has been made a necessary part of the procedure. Right to being heard is a necessary part of the procedure, and the due process of law clause has been construed to have incorporated the rule. In Great Britain, the rule is deduced from common law and the concept of natural justice itself in India. The procedure is established by law. So if any statute fails to include the rule, it cannot be taken for granted. In all cases, unless and until it is not prohibited in express words, it is deemed essential to natural justice. Under the Constitution itself, there are provisions which gives an opportunity to show cause while any action is taken against a government servant in connection with his dismissal or reduction in rank. Under Article 311 of the Constitution, Clause 2 clearly provides no such person as aforesaid shall be dismissed or removed or reduced in rank until he has given a reasonable opportunity of showing cause against the action proposed to be taken in regard to him, provided that this clause shall not apply where a person is dismissed or removed or reduced in rank on the ground of misconduct which has led to his conviction on a criminal charge. Where an authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reasons to be recorded by that authority in writing, it is not reasonable, practicable to give to that person an opportunity of showing cause, or where the president or governor, as the case may be, is satisfied that in the interest of the security of the state, it is not expedient to give to that person due opportunity. Thus, we find that except under the above three conditions, a reasonable opportunity to be heard has been clearly guaranteed. In India, reasonable opportunity of being heard clause has been given statutory recognition in almost all cases. Without it, the true end of judicial hearing will be frustrated, and it was realized by our constitution maker as well. So that's all about this video where we have discussed about Audi Alteram Partem. If you like my video, please like and subscribe my YouTube channel. Thanks for watching.